All right, imagine a family dispute so intense, so dramatic, that it actually ends up cementing a fundamental rule of contract law. Today, we're diving into this explainer of a landmark legal case, Venkatar Chinnaya v. Venkatar Ramaya Guru. It's got all the elements of a great story, a generous gift from a loving mother, a broken family promise, and a high-stakes courtroom showdown that answers a genuinely tricky legal question. Now, before we get into the specific facts of this family drama, I want to pose a central question to you. Put yourself right in the shoes of the judge for a second. Can you sue someone over a broken promise if you personally give them absolutely nothing in return? I mean, it seems completely counterintuitive, right? Usually we think of a contract as this strict two-way street where both people have to exchange something of value. But well, as we'll see as we analyze this case, the answer isn't always that simple. Okay, let's dive into this and look at exactly how it all unfolded. Step 1. An elderly mother decides to gift a very valuable piece of land to her daughter. It's a warm, generous act, but there's a condition attached. Step 2. Before finalizing the transfer, the mother makes the daughter promise to pay a regular allowance, an annuity to her brothers. The daughter happily agrees, signs the agreement, and the land is hers. But then we hit step 3. After securing the property, the daughter just stops. She completely breaks her promise and cuts off the payments to her brothers. And this conflict centered around a very specific number. You see, the daughter hadn't just made some vague, I'll help you out kind of promise. She explicitly agreed to pay her brothers exactly 653 rupees annually. This specific financial commitment was the literal core of the agreement. So when she just stopped handing over that 653 rupees every single year, the brothers didn't just let the issue slide. They actually took their own sister to court to demand what they were promised. So picture the tension in the courtroom as both sides present their arguments. The daughter's defense was actually pretty straightforward. She argued that the agreement wasn't legally binding because the brothers personally offered her absolutely nothing in return for that money. And honestly, on the surface, that sounds logical. But the brothers forcefully pushed back. Their claim was, look, our mother gave you that land strictly on the condition that you pay us. It was a brilliant, incredibly tense legal standoff. You can just imagine the heavy silence in the room as the judge prepared to settle this feud. Who actually had the law on their side here? Well, the court delivered a decisive ruling. The sister is legally obligated to pay the annuity. The judge completely sided with the brothers, determining that their agreement was, in fact, a valid and fully enforceable contract, completely shooting down the daughter's defense. And this brilliantly illustrates exactly why the judge ruled the way they did. The court held that she was obligated to pay because, and I quote, the land from their mother counted as valid consideration for her promise. Basically, the judge recognized that even though the brothers didn't hand over anything directly to their sister, the sister had already received immense value, the land, from their mother. That piece of land was the legal anchor that made the daughter's promise to pay her brothers absolutely binding. Ultimately, this whole family feud gives us a perfect, real-world definition of consideration, which is simply the value exchanged to create a valid contract. But more importantly, it establishes a golden legal principle. Consideration may move from a third party. The mother, acting as that third party, provided the necessary legal backing to enforce the contract for her sons. It's an empowering realization for law students. So the next time you're looking at a contract, ask yourself, who is actually providing the value here? And could a generous third party be the one holding the entire agreement together?